I was looking for that petition of right in Scotland, or claim of right. Sorry, I was looking for that claim of right in Scotland again. Although I've already read it, I've already got quite a few excerpts from it. But I was just wanting to get the link for it again because I'm going to complain about this Gail Bradbrook case because I think she's getting sentenced tomorrow. The judge said that there was no defence, but there is, because her actions could have been viewed as an advertisement for the campaign, like an act, even breaking the window, part of an enactment, a representation like theatrics. It can be classed as an advertisement, and therefore you get deemed express consent, even if it will cause damage, because you're using an enactment and he's giving you permission. The thing is, the window's insured anyway. The window's insured, so the window gets paid for. It's all to do with whether you're a criminal or not. The problem is that judge guided the jury that there was no legal defence. Now, we know that with the Ian Bray case at Southwark Crown Court with Judge Gregory Perrins, he said there was no legal basis, but yet the jury can still find you not guilty, even if there is no legal basis. But this judge, apparently with Gail Bradbrook case, was saying, don't judge with your conscience. But what he did, that judge, is he misguided and lied. He's trying to claim that there's no legal defence. Firstly, it's questionable whether these cases are lawful anyway, because this act here, right? This act here. I found an even earlier one now. This is 1628 one, Petition of Right. And then this is talking about that Great Charter and so forth. It's talking about exemptions. It's talking about claiming exemptions from prosecutions, even in this one. So there is more and more and more legitimacy to it. But this one refers to all the statutes of the realm and so forth, and then it refers to that Great Charter. But there are some other statutes, there are some other laws and statutes. It's always going on about upholding these statutes of the realm and the rights of the realm. A lot of these are basically like, fair trial and fair judgment, because we're executing people as well, So it's the right to, being judged fairly and so forth, and through proper procedures and so forth. But again, it refers to exemptions and so forth. But I just want to say something to do with this act. There was a guy on Richard Verb's channel, and he was talking about a guy from New Zealand, and he was saying that Magna Carta is fake or false, and he's been, Runnymede, and there's no evidence that King John was there, and there's no evidence for Magna Carta, and so forth, right? Now, the thing is, some people like to make jokes and make a poetic point when they make acts of law and in the naming of them and so forth. Ministers even do it now. They put things that entertain them in the law. So this Runnymede, it was signed at Runnymede when everyone was drunk and so forth. It's almost like a joke now with McDonald's and Burger King, but it's all overweight and so forth. Just the whole joke of it. The whole thing about people doing things with drink. Runnymede, and the fact that apparently you can't get horses onto Runnymede anyway. A horse, my kingdom for a horse. Something Shakespeare from that. But the fact is, right, Magna Carta is, the name of it is to do with, powerful document, Magna Carta, the magnetic scripts, the text that people comply with, obey. But yet it also does refer to the cart. And there's something in that, like a cart, because one of the main clauses in that Magna Carta is about, they can't take your cart away from you. And when in the medieval times, when you would, use a horse and cart, when there were people walking and you had a cart, it would attract people towards it. Always it always attracted people towards the cart for lifts and so forth, particularly if it also was carrying goods and so forth. Particularly robbers and so forth, maybe even obviously people wanted a lift. When I watched that video of Verbs, the thing is, Magna Carta was written around the time of the founding of Oxford University by the monks and so forth. It ties in with all that. Whether or not it was legitimate or not, it surely was written by someone who had views on laws and someone who could write, and there was very, very few people who could even read and write back then. So you're looking at academic people. So even if it was forged later. But the thing is, that guy from New Zealand who appeared on Verbs, he was saying that he claimed that Magna Carta was forged later on, much later, not even around the time of when it was supposedly written, but a later, thing. But there is actually, in this 1628 Petition of Right, I read it, right, and there is actually, believe it or not, in this act, in this petition, it does say here that is declared and enacted that no free man may be taken or imprisoned or be disseised of his freeholds or liberties or his free customs, or be outlawed or exiled, and any manner destroyed, but by the lawful judgment of his peers of the law of the land. So that is like, right to a fair trial and so forth. But it says judgment by his peers, so that's by jury. So like that, you see, the thing in Magna Carta, right? One of the main clauses in Magna Carta that stands out to me and stood out to me when I read it is the one with the barons. Like, barons and lords can only be judged by their equals, right? But if barons and lords could only be judged by their equals or by their own class, right? The thing is that means if you are a serf or a freeman or even, peasant or whatever class you're in, you have to be judged by your equals. Now, your equals are your peers, not the barons and lords' peers, but yours. So it says by the judgment of his peers. So that's like the jury, or by the law of the land. Well, that's interesting because it says by the lawful judgment of his peers or by the laws of the land. So why would the laws of the peers be different to the laws of the land? It seems to say that, is this like social justice? I mean, if you work a job in Royal Mail and, you're not pulling your weight and your peers think that you're slacking, are they allowed to punish you just by, playing tricks on you or pushing you around until you start, doing what they think you should do? It's almost like a natural law, isn't it? That a natural law. Well, if it's not by the laws of the land, what laws are the judgment of his peers? Does that mean that everyone is judged by their own family or so forth? What's the differentiation between peers or by the law of the land? But by the law of the land, this act is full of references to statutes and the Great Charter and so forth and so forth. But it says by judgment of his peers. Now, if the Magna Carta was legitimate and was, 500 years before this act or whatever, this would, if barons and lords could only be judged by their equals, then surely all the rest of the people are judged by their equals as well. But this is jury. This is the basis of the jury. But it says all by the laws of the land. So, this is almost... That is odd, because the thing is, when you go back to the Druids, the whole Irish system of, apparently the people voted for who was going to be on the council or the king, right, who was going to be in charge of the clans, supposedly, but yet they made the laws, but yet the judges themselves were independent. So it's almost like that whole Irish thing, Murphy's Law. There's always that Murphy's Law. Well, who's Murphy? Well, it depends what village you're in, doesn't it? Because if every different clan with different kings has got different laws, then, it's the law of the clan, then the law of the land, the law of the clan, because every different clan has got different laws. So it's it's Murphy's Law, is it? All right, well, what about this clan over here? Well, that's Jonathan's law. Clan Dudno, Clan Berry. So what are the laws in Clan Berry? Well, that might be Murphy's Law, all right, but what about Johnson's law? Boris Johnson doesn't have any laws because, this is it. What about the laws of, the Brigantes, of the laws of the Savonia, or the laws of the Caledonia, or the laws of whatever? This is it, different laws for different lands. So like this whole Murphy's Law thing is, but the ironic thing is, regardless of all the clans having different laws, apparently it was the independent judge, the jury, who were the judges, so they could judge either way they wanted. So the ironic thing is, at the end of the day, if there were loads of different laws for different clans, but someone's deciding on the matter independent, like a judge, then it doesn't really matter what the law is, because at the end of the day, the judge can decide what he wants regardless of what the law is. So, if you can see that and understand that, then, it's all down to the judge. It doesn't really matter what the law is, because, although something might be lawful or unlawful, the person who's making the decision has got the right to decide either way, depending on what he thinks, which comes down to the whole thing. It doesn't really matter about Murphy's Law then, does it? And this is the whole thing when it comes down to, seeing and understanding. But, we need to look into this. Needs to be studied a little bit more, because this is really, really important and relevant. But this suggests that the Magna Carta, this barons and lords can only be judged by their equals, doesn't come from nowhere, or at least this is a proper act of law. This petition that has got some reference to people being judged by the peers, depending on what peer group you're in. So, but what interests me in this act now is this here. But what are your liberties, though? Dissest of his fields or liberties, but what are the liberties? But it's saying that there are all these statutes. See, at this stage, there are all these. There's a great charter, the laws and so forth given to the people, and there's a lot of other statutes that he goes on about. I want to know what they all are, because there might be some more clues in those. But this is interesting. But this freeholds, I would take that as he cannot be dispossessed of his freeholds or liberties, or free customs, or be outlawed or exiled. But that suggests that you can't be taken of your freeholds. That would suggest things like, your cart and the wood and so forth. Now in Magna Carta, you can't have your cart taken off you, period. Or your wood. You can be fined or imprisoned, but they can't take your things off you. Well, this is saying that they can't take your things off you or your freedoms and so forth without fair judgment of your peers or by the law of the land anyway. This would suggest that your peers or the law of the land could take your freeholds or liberties. Well, your liberty is your freedom, isn't it? If you're imprisoned, you haven't got any liberty. Or free customs, or be outlawed or exiled. So they're doing outlaw and exiling, really. I thought they banned being exiled at that point. There's something with this freeholds and liberties that suggests that there was something about not having you take your freeholds away. And for that reason, this little part to this act, it suggests that there's something to Magna Carta that it might be legitimate. because, you know, that other guy was saying that there's no evidence of it or no sign of it in the law at all, like no trace of it whatsoever. It just appears, and he claimed that, you know, like, you know, it not been legitimate, or, you know, it was written at a later date. But this suggests that there is something prior on more than one account. Not only not being allowed to have your fields taken away from you, right, but also being judged by your equals and peers. So I don't think that guy from New Zealand is right. I don't think Magna Carta is fake, or if it is, at least it was drafted up by someone who knew what they were talking about, an academic, and not many people were academics back then or could read and write anyway. So at least, you know, it wasn't, you know, even if it was a forgery, you know, it's almost kind of like now if, you know, if Professor Tim Wilson wrote himself an act of law and pretended that it was real, at least, you know, if it was written by Professor Tim Wilson, you know, well, who else, you know, is this the man that you'd want to write the law? You know, he's better than, you know, someone writing it from, you know, well, I don't know, you know, it's better than someone writing it, you know, on the back of a, you know, betting slip from William Mills or something, isn't it? You know, there's too much in this that correlates with Magna Carta. There's too much in this act which is raising up things from like what are in Magna Carta. I don't think Magna Carta is just like, you know, fake. I don't think it is. You know, there was a lot of question because they said that, you know, it was annulled, and, you know, there was all this hassle and palaver over it. The time that they did it was the time of it. I know that they've always had the ancient Greeks and so forth, and even Stonehenge was meant to be, you know, the Druids and so forth. But the thing with the early church, we've got this kind of like official. I know we've always had, you know, they've always had the academic buildings of whatever sort, might have been made out of wood, not even, you know, monasteries or whatever. But this kind of whole, the birth of the university and the whole educational institution, kind of like times with Magna Carta, there's something to the academia of it. But also, in this act, and this, I think this is before the Civil War, because it's Charles' Civil War, isn't it? This also talks about soldiers going into houses, which is meant to happen in the Civil War, but I think this was a little bit before that. This also talks about exemptions in law and claiming certain exemptions. It's also about due process of law. It's always about due process of law. I mean, disinherited, put to death without due process of law. But there's something also about, there were some soldiers and mariners going around causing trouble in this, which is kind of a little bit like the Civil War when they had all the soldiers were raiding everywhere and so forth. But they're going round. These commissioners have got powers to go around and administer justice, and there might be some exemption for them going around administering justice. But there are people claiming there's habeas corpus in here. Look. Nevertheless, against the tenet of said statutes and other good laws and statutes of your realm. So we need to know what these are. We need to know what they all are by name, what they're all called. And this is like 1628. And I don't think Professor Karen Bowie, has listed everything, although she with a lot of the articles and so forth. But I think that's a bit later. Right, so they've got this. They've got people going in front of the Privy Council and getting judgment according to. They've got people going in front of the Privy Council. Now, this is important because the thing is that they didn't have a parliament all the time, and it was like very, very, very early. When you still got like, the medieval time, it's just like kings and queens and so forth. So you've got this tradition of, like when you think of, a medieval movie and you've got the castle and the knights and so forth, and it's all like, jousting and so forth. You see, you don't have parliament in those movies because you've got the king is making judgments, although you've got, like Cromwell, not Cromwell, Oliver Cromwell, like Cromwell's ancestor, like lawyers, Privy Council, all around the king. You got judges going round, but they're coming back to the monarch and so forth. There's not this parliament sort of authority as we know it, or as when they were starting to get MPs elected and so forth. So you've got this, if they've got this petition right, and it's in the Institute laws, and there is an exemption, it's the thing is, if it says you can be judged either by your peers or by the law of the land, that's strange, because that suggests that, there's a differentiation. Now, the thing is, if something's been stolen, if someone in a village gets something stolen and you're trying to sort it out, right? And your peers know that, then they know that what you're doing is for that purpose, and you're not going to be. They know that what you're doing is, for law, upholding the laws, or at least, for. So their consent to what you're doing means that they're supporting what you're doing, which means that, like, if Bob robbed John's shirt and people knew that, and then you say, right, I'm going after it, then they say, okay, go for it with our blessing, if you know what I mean. What it's saying is, right, yeah, we acknowledge you're going after that shirt, therefore obviously you'll have to grab hold of him, and you've got to do what you want to get, you've got to do what you got to do to retrieve it, if you see what I mean. So they are, advocating your actions, if you see what I mean. So you're not the criminal. It's acknowledged that someone else has done something, and you have been acknowledged that you're going to sort it out, if you see what I mean. Now, if your peers therefore aren't going to condemn you for that, they're actually supporting it, and there is a differentiation between by peers or by law, then how can you be... You see, this is like when you get in the jury with that Ian Bray thing, isn't it? It's almost like with Ian Bray when the justice goes, well, there's no legal basis for it, but the what happens if all the jury are supporters of Extinction Rebellion? Well, they support it, don't they? It's like if something got nicked, everyone supports you going after them and doing what's necessary to get it back. So this needs looking into further. But the thing with the Privy Council is, this suggests that there's a certain procedure that is not by local courts or justices, but to the Privy Council, and it's judged by the Privy Council. Now, if that's the case, the 1661 bill, the Tumultuous Act, confirms that, because it's King's Bench. But if in 1688 they make it illegal to be prosecuted by the King's Bench, does it mean that you can't be prosecuted at all? Does it mean that if you've got signatures on a petition, they are advocating your actions as much as, like on this, your peers? Like, your peers can judge you, and if your peers decide that what you're doing is okay, then it's okay. And that's why the law doesn't apply, or by law. Well, if your peers are supporting it, then they're saying that it's all right to do it. That's what this suggests. Where's this? So, but and you see, you've got this great. Talking about the great grievance and vexation of the people. To raise realm and has been, their wills have been compelled to receive them into the houses and to suffer against the laws and customs of this realm and to a great grievance of it. So they're using these soldiers and mariners have been just going around and in the form of the Great Charter. I'm sure I've read that Great Charter, but it was quite a while ago. Probably need to reread it. The Great Charter and other laws and statutes of the realm. We need to find out what these are. I want a list of all of them. I want a list. I need to find out every single statute and all these good laws and charters that were in effect in 1628. But then where is this? There's a word in here. There's a word and it says exemptions. And that is... I'm just trying to find out where it is. Directed contrary to the statutes of this realm. All right, here, look. Right. You've got people claiming exemptions in this. They're claiming an exemption. Have escaped the punishment due to them by the laws and statutes of this realm, by reason that diverse of your officers and ministers of the justice have unjustly refused or forborne to proceed against such offenders according to the laws. So there were some people claiming exemptions. But look, and also sundry grievous offenders by colour thereof claiming an exemption. Now it says it a few times in this act, by colour. Now I really don't think, unless you're talking about, the Crusades or whatever, I don't think it means like skin colour. I think that we've got some, you see, in that 1688 bill, there's a lot of discussion and talk about religious discrimination between Catholics and Protestants and, the Pope and so forth, and a lot of persecutions and prosecutions about their faith. And a lot of religious discrimination, which is why there was protections and exemptions from prosecution a lot of the time for petitioning, right? But here, we've really got some evidence of, I think that this is eye colour. Because what other colour would you have? Unless you got gingers and freckles. I think this is eye colour. I think this is... you wouldn't think that, there are no black people around hardly or very few. What form of racism could you have, I think that this is evidence of some medieval racism, or not necessarily racism, but like issues like later on in 1688, you're looking at all different religions and so forth. It's including the words exemptions in with by colour, but in the same word as exemptions. Now, the only other act that I can explicitly raise and mention that covers this area is in the Magna Carta, because you've got barons and lords can be only judged by their equals. But what are their equals? Who would be anyone's equal and who wouldn't be their equal? This is the thing. Now, the thing is, when you're a baron, you're an equal because how much money you've got, if you're rich or poor. Barons are barons, this is class discrimination, not religious discrimination. But if barons and lords can only be judged by their equals, this is class discrimination. This is money. How much money have you got? What's your title and rank and lands? That is not like what's your religion, or are you a Catholic or a Jew or Protestant or, the Pope or whatever. This is money and class. Now, at the moment, we've got a lot of issues around the fact of, racial discrimination. But you see, the thing is, I've been thinking about this a lot, like now we've got Sadiq Khan and Rishi Sunak and, Sola Braverman and people like that. And then you've got these, like an Indian gentleman, a native Indian gentleman, and he's like, Punjab, I know my sir, how are you doing? Very well. He's got the accent. I mean, that's like a Welshman who's got a Welsh accent. Those people have a certain skin colour, but they're also, the accent is of a country. Their accent is of a country. It's not just the fact that their skin colour, their biology, their bred, they're a breed of a country. I mean, the thing is, like, Sadiq Khan, he sounds like a Londoner. He talks like a Londoner. He's load. If you had a computer, you load Windows onto it or whatever. He's a Londoner, right? We're not disputing that he's not British. He's a British Londoner. But his origins are from abroad. You can see that without arguing. There's nothing wrong with identifying that. The police have it on a form. Police say, you're Irish or Caucasian or whatever. You tick a box. The police have that form. It's almost like if you have a computer in India and bring it to England, but you load Windows or whatever you want. Or Apple or whatever, or Linux onto it or whatever. You can load a different operating system onto it. So the thing with this barons and lords can only be judged by their equals. When this whole conquest, this whole 1066 and the Battle of Hastings and the Normans and the French, and they're meant to be nasty to native English people, and they've got their castles and their monasteries and they're administrating the country, and they speak French. These French speakers, their peers, and they're in their own peerage. We've conquered you. We're the French. We're the Normans. We have our own. We speak French. We have a lot of money, and we're in charge, and we're surveying the country and taking over. That's a class. Now, that is really what the Tory party, we went to private school, we've been loaded with a posh accent, we take a lot of money from people, we're the ones with the money or the ones without money, we do business, and this is the whole, so you've got this whole class system. But the thing is, anyone, it doesn't matter whether you're African, Indian, like Kwasi Kwarteng, it doesn't matter whether you're African, Indian, Chinese or whatever, you can go to a private school like Rishi Sunak or Elon Musk, and you can be taught to, have a certain accent, and this is how you live life. We're the ones with the money, we take the money and so forth. And then you convey yourself in society in that class, right? That's the model, really, that Magna Carta proposes, that, barons and lords can only be judged by their equals, a certain class, elite. Now, the thing is with that elite is they're the ones who can really only afford the very expensive, posh legal help anyway when they break the law, Now, the difference between the Magna Carta, which claims to be a lot earlier than this, goes on a peerage system, right? The ironic thing about this act now, which is a lot later, because this is, like early 1600s, 1620s, right? The thing with this is it's using the word colour, and it's suggesting that offenders by colour thereof claiming an exemption. Now, does it mean that they've got a coloured speckled band, or like a different shield or something like heraldry? Is it talking about by colour, by hair colour or heraldry, or what does it mean by that? We could do with looking into it to find out, because this is the time that the early 1600s, and then going back into the 15 and 1400s, and then 12, 13, 14, 1500s. I know that's a bit of a wide span to cover, but you've got all this like weird stuff, like the pig's head on the table with like the eye colour of the pig and stuff like that, and a green apple in its mouth and something and all that, which I have always identified that as quite racist, really. When they talk about the pigs and then green apple in its mouth and stuff like that, this has got connotations of that. The thing is that there's a theory. There's a racial theory that, you get people who are taller and people who are shorter and people who are fatter and people who are thinner and people who are, more redhead or less redhead or this or that. And there is a theory that there are some certain differences between people, right? And if that could be proved, no matter what those differences are, and there is a different level of understanding between certain people, then it's interesting to wonder or not whether certain people have an understanding that other people don't, or a way of seeing the world or seeing things the way that other people don't, or an altruistic culture or something, That matter is always seeming to be looming in the background in some of these acts, whether it's, but they always refer to it as class. But if you can be regarded as not equal to another man, in the Bible it says all men are made equal. But in all these acts, people definitely aren't being regarded as equal. You've got your peers, barons and lords have their equals. Other men aren't equal to barons and lords. So you've got this, I would say, racism, because it is really racism, and they call it class, but it's as bad. I would suggest it's as bad as all the religious discrimination that is covered in the 1688 bill and all this Catholic Protestant stuff, because it doesn't really matter what subject you go on to. It doesn't matter whether it is religion or whether it's money, class, elitism, which you group education, money, and family with that, or whether it is colour, whether it's, because at the end of the day, if you strip, 50 men naked and stand them in a line, how do you know who's the rich ones and who's the poor ones? Is until they open their mouth and speak. What education have they got? What language have they got? What law do they know? If you take all their money off them and stand them in a row all naked. Now, the thing is, if you've been taught the law and learned the law, then you've got the advantage of defending yourself legally through knowledge. But the thing is, if you haven't learned any law, as a raw, stripped human with nothing but what God gave you, Are there any differences to how you see the world, how you reckon, how you work out what's right and how you reckon what is right and wrong, how you work out what is right and wrong? Well, according to this, remember, it says judged by their peers or the law of the land. But there's a differentiation, either or. So if you're not going to be judged by the law of the land, then you're going to be judged by your peers. Now, what are your peers? Now, it suggests in Magna Carta that barons and lords' peers are the other barons and lords. Now, they could supposedly be of any religion or colour. But what happens if you've got a lot of Protestant lords and a load of Catholic lords? You know, I mean, they could all be rich and all be members of Parliament and all have lots of money and all have been to Oxford, but some of them might be Catholic and some of them might be Protestant. So if the barons and lords can only be judged by their equals, then hopefully if you're a Protestant baron, then you would hopefully not really want to be judged by a load of barons who you are equals, but they're Catholic. Because that could be particularly a bad outcome, given the fact that they were imprisoning and persecuting people because of their religious meetings in private houses and rooms in the 1688 bill. So you've got these axes, these multiple axes of different dominions, you know, denominations. You've got wealth, you've got education, you've got race, and you've got religion, and so on. And all of these acts at some point seem to focus on, depending on which is the discrimination of the day, it's almost like, you know, plank of the week, like they have on you know, talk radio, plank of the week. It's almost like grievance of the week, isn't it? Oh, what's the grievance in this bill? Oh, it's the 1688 Bill of Rights, Catholics and Protestants. And what's the grievance, the latest trend, the latest grievance, you know? And now we've got Sunak and Sadiq Khan, you know, taking our rights away from us, you know. And then back in, you know, 1628, you've got, different colours here. Now it's eyeballs, you know, not skin colour. So, and then, you know, go back even further. Now it's rich or poor again. Now it's the lords and barons versus the commoner with his handcart, you know. But there's enough in this act to suggest that it's referring to a lot of things that were raised in Magna Carta. So I think that this suggests that it could be legitimate, the Magna Carta, which is still regarded as legitimate. I think this strengthens its case for legitimacy. But we've got this exemption word. But there's a connection here of colour, of claiming an exemption. How would you claim an exemption from colour? You're not claiming an exemption because you're Lord Hanningfield and you've got parliamentary privilege, are you? It's by colour. Now, if in this it says that you can only be judged by your equals, the thing is, what happens if, I mean, if you were in Africa on a safari and something happened, an incident, right? Would you want if you're in a safari in Africa, right, and there's like a hunting party of people from England, right, and there's an incident with some Africans, right, would you want to be judged by, your fellow group, who decided whether you were bad or not, or would you want to be, judged by the cannibalistic, Hinkum tribe, who might have you like R2-D2 tied to a pole and cooking you over a stove? This is the thing. Would that be fair? Would there be? Could you be could it be possibly, could they come to a racist conclusion, particularly judging on the fact that they might have different traditions and so forth, and deem punishment to be eaten for lunch, So this kind of like, in this act, when it says judge by your peers or, by the law, that's very, 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 very interesting. And coming more into the future now with that Ian Bray case, seems like the jury, if the jury are Bray's peers, working class people, or by law, seems that they can override the law, which makes you wonder, if you've got a campaign, that a lot of people are supporting and they all advocate it, then aren't they advocating your actions if they're all supporting your actions, regardless of what the law means? So, but Gregory Perrins, says that, he said there was no legal basis. Apparently, according to this, you don't need a legal basis if your peers don't think that you've done anything wrong. So, what is this exemption? Is it in some of these other statutes that are referred to? Is the exemption in the statutes or in the Great Charter itself? So, I still think that if you're petitioning the Palace of Westminster, it's a case to that authority, and I don't think that the Crown Court and Magistrates Courts are allowed to try cases that are already an existing matter being petitioned or brought to Parliament. I still think that it's like Privy Council. This Act suggests that it goes back to the fact of before Parliament, and they had judges going around, and the King's judges and so forth. But you can get judged by the Privy. You can have judgments by the Privy Council. You can be in front of the Privy Council. Now, why would you be in front of the Privy Council if you've got judges around the country? Why would the King waste his time with you? Why would the Privy Council waste their time with you? Why would you be up in front of them if they've got judges going around on circuits all the time? It must be a different matter. Or a more important, serious thing, I still think that even from reading that 1661 Act, and from the fact of that Petition of Right, with you can't be imprisoned and so forth. That Petition of Right makes it clear that if you've been petitioning, you shouldn't be imprisoned. And it does extend to all the activities that involves petitioning, including it does cover these rebellious behaviours and so forth in public and things like that, misdemeanours and so forth. This would suggest that, it's not just the letter of law that applies, that there's something in this which applies to, like the jury and so forth. And if you look at the Tumultuous Act, the petitions in cases went through a grand jury or the justices. Well, that would be suggestive of this, wouldn't it? Your peers or by the law. And if it was going by the grand jury, they could decide either way. The thing with that extinction rebellion action is that it's ridiculous that some people have done similar or the same actions and acts and been treated differently from case to case, which is quite unusual. But, obviously I haven't been doing enough research. I think I've done quite a lot of research, though, to find that Professor Karen Bowie paper and to even find this now has popped up and the Tumultuous Act. And then we've got, we've got Fitzgerald's book, which I haven't even actually read it all yet, which didn't have the Tumultuous Act in it. I wonder if he's got all these statutes in it. Maybe he's got all these statutes in the Great Charter in there. Maybe I need to check. This is look, they're claiming exemptions. And he's got references to colour. So, I ain't write it. And I definitely think that there's something in this whole... This is... What this is suggesting from this one is that it looks like it's peer-based. It looks like the powers are actually coming from the people, and if they're supporting what you're doing, a certain number of people, the public or, your immediate community or whatever it is, or at least, a section of the public. A section of the public, my mouth's going a bit dry. A section of the public, or, it's justifies, it's somehow justified. And I don't mean like, if like an entire village decided they were going to go rob a bank and say that it's okay to do it. We're talking about acknowledged and justified for a reason, or you've got a cause, And the thing is, by the laws of the land say you can't rob a bank. But the thing is, if something has been stolen or robbed or done wrong, then, people need to identify that and say, okay, we need to put it right. And what do we need? What can we do to put it right? Well, we need to do whatever we need to be able to do to put it right. Even if it might be against the law of the land. But that's the thing. You can have a judge make a decision or an order, or the jury. But in most cases with the Crown Court, it's the jury with the judge together. But then you've got this ability to override it. Now, the thing is, with these trials, like at Isleworth with Gail Bradbrook, she's already got consent of a section of the public, and it's a political matter that has been acknowledged. So the thing with the petition is, it is a legal case. It is a legal proceeding. And you're collecting the people's support on it. That's the ironic thing. So you're accumulating support as you're going along doing it to say, we support what you're doing and keep on doing it. And then it goes to the ministers to debate the matter. So it is an actual legal proceeding and casework. It's not like a criminal or civil case where you facts and circumstances happen and it has to be looked at. The final part is with the public in front of it. It's the public. Even the word public inquiry. Where does the word public inquiry come from? They set up a special court with given certain powers, but it's the public. Well, is it for the public? They're doing an inquiry for the public. Oh, thank you very much. You're doing an inquiry for us. We're the ones doing the inquiry. It's the public making the inquiry. Or we're doing it for you, for the public. Well, it's all for the public, isn't it? The whole thing, supposedly, even the police. But, the whole concept of the term a public inquiry suggests that the public are looking into something, not just like, PC Watson or Officer Dibble, the public. Now, the very thing that a petition is, when you're accumulating signatures from the public, is that the public is supporting the inquiries you're making into something, whether it's to get the law made or changed or something that was done wrong or that needs looking at. The whole, it's official and they're consenting what you're doing for this. So, I think that you've got the consent of the peers through these actions. And the thing with all the damage and so forth is, everything's insured and they get paid out for the buildings and so forth. I know it's sad when that tree got cut down on Hadrian's Wall. It's irreplaceable. But I think that, was a bit of a freak occurrence. Things like windows aren't, unique and priceless. It's upsetting and sad if a window gets broken, but at the end of the day, unless it's like a vintage window from a, Tudor house in Shrewsbury that's, one of a kind, it's unlikely to be targeted by a petition unless it's like Elon Musk getting these modernists to go around smashing up the history of England in order to, build new spaceports everywhere. That would be a tragedy. But, things that are plentiful and commonly easily replaceable, like, Department of Transport window or whatever, it's, this government like new windows. They're wanting to destroy buildings and build more new modern things. They're wanting to rip out everything and put bike lanes in, pull trees out. Councils are doing it all the time. So the council themselves and the government are advocates of ripping windows out and buildings and so forth and putting new ones up. They're perpetually wanting new windows all the time. You can't keep up with them. We want a new department of innovation and technology. New. Out with the old, in with the new. This government can't. They're addicted to new things. They want new all the time. So the Department of Transport getting a new window, you'd have thought that they probably they would have welcomed the new window being paid for by the insurance. I don't think that these cases are meant to be in the Crown Court or Magistrates Court, if at all they can be prosecuted anyway. I think they've got the consent of their peers, like set out in this, and the cause has been justified and advocated for, like it says in here, by the peers, who have supported the petition, and the legal basis for it is here. This is the legal basis for it. I think this is the legal basis for that 1628, and if this is the legal basis for the peers, not the letter of law, advocating what you're doing, then that would explain the whole thing. Would justify the exemptions in pursuant of, and even if it was King's Bench, it definitely wasn't. If you were going to get it looked at, it's saying King's. It's not the. I don't think it's like the Magistrates Court. I think that it's like the authority that the petition's to, and that would be Privy Council or Palace of Westminster. And this gets more and more certain the further you get towards 1688, when it finally says, okay, right, you can't prosecute at all. Because, I mean, you've got the barons and lords. Barons and lords could be prosecuted in Magna Carta by their equals. Barons and lords could be prosecuted by their equals. They were completely exempt. Even doing work for Parliament, they could be prosecuted by their equals. It doesn't say, there's no, all it says is that they get prosecuted, if they break the law, they get prosecuted by their equals. It doesn't say that they've got any exemption for doing parliamentary work or not. It's to do with their rank and title, peerage. With the right to petition, it's about the purpose of your actions and what you're doing. And if your peerage is signing it, then you're getting the consent from the common people, from commons. You're getting consent for what you're doing, your casework. I think that those signatures are the authority, like in the Town and Country Planning Act 1990 and 2007, when you get deemed an express consent given by the law. under Class F to put the notices up everywhere without needing permission or even painting, because the law gives you express and deemed consent through the use of an enactment. And you don't ask for permission from a person, the police chief or the councillors or whoever. It's the law. And in this, it's saying by your peers or the letter of the law. So, or by law. So this is the thing. You're always looking for, permission, approval. But the law gives you permission. This is the thing with trying to get things published now. Like DistroKid or Amazon. Oh, have you got consent from the copyright holder? The law is giving me permission. The law, by letter of law, gives you permission. Why am I asking? Why do they need a person's permission? It's supposed to be what is written in the law. But when it comes to the petitioning, the law gives you the right to do it without being prosecuted. But the thing is, you're also, one of the things that you do with it is you get consent. You get consent from the people who support it. Because and what that does is it acknowledges that it's legitimate what you're doing. A reason exists for doing it. Usually a reason that is justified. And so forth, and the thing is, you don't go to a jury for a second opinion when you've got the consent of the public already, because that case is in the interests of the people already, and it might not be in the interests of people who are opposed to it. And because there's people who are opposed and against it, you've already got a division. And with that division, this is why you're having the case heard by Parliament, including all facts and circumstances concerning it and what you did and so forth, which is why it's suggestive of, Palace of Westminster or even Privy Council and not the regional courts, because it's not a regional court matter or even a Crown Court matter or a civil court matter. It's a governmental level matter. And I just don't think that these judges or magistrates like that. Why would you go ask a jury that could be either for or against a political cause that's supporting, when you've already got the support of your peers for that political cause, or for people to whose interest it serves, in the interest of the public, a section of the public, or not the public at large, but at least a section of the public who support it. That's the thing. There is a section of the public. You get that in the Referendums Act, publishing and making it available to a section of the public or the public at large or whatever. This is, to me, this is adding so much more clarity and confirmation to it, that there are so many parts and clauses in this that are important, But that's the 1628 Petition of Right. Still need to look into this even more, but this is, it's filled in so much now with pieces of the puzzle that I don't think that there's any contest or doubt to it. And I only think that these other statutes and further things in this are only going to solidify it even more and more and more and more, because it's quite clear now.